Science and technology and innovation, these are indispensable in the modern economy, in the modern world.
We held a meeting at the MSI, and we resolved among about 6 to 8 of us, local members, first to form PAASE Philippines so that we could continue to host meetings here, but also to go on a massive campaign to try to get support from the national government through the legislative and executive branches to invest more in science and technology. So it started with a white paper, a position paper that we co-authored among 6 of us, namely Ernie Pernia, Cesar Saloma, Rador Asansa, Toby Dairita Fateneo, and Aldin Colaba de la Salle, and myself.
So PAASE historically, in the past 10, 20 years for sure, have been collaborating with our counterparts here in the Philippines at various universities. And a lot of these interactions probably started as peer-to-peer. But thankfully, we have the Department of Science and Technology here in the Philippines, and they've come up with some really helpful and very impactful programs that actually enable PAASE members that are based in the United States and other parts of the world to actually come here and do extensive research and academic partnerships and collaborations.
Well, I think that one of the good things that PAASE is doing is really trying to stay in touch with the researchers and the scientists here in the Philippines. So I think that is one of the good programs that they keep on supporting some of the initiatives of our researchers and scientists here in the country, trying to align also their assistance towards the plans of the Philippine government.
It's very important that the PAASE members and scientists based in the Philippines are continuously in contact, so we will know the needs of the Filipinos and opportunities that Filipinos can have to do science with their PAASE counterparts. So these interactions, such as the conference that we're holding and the annual conferences that we have.
The Philippines and the scientists there have very unique perspective that adds to discoveries and inventions, advancing in general the field.
These members, because they are part of an academy, it implies that they are productive. So they have publications, they have innovations, they have inventions, patents, and they have, they have an impact on society. Okay, so these are the people who can convince government, invest more in science and technology. And that was really the gist of our paper, our position paper in 2000. And it is Ernie Pernia who said that R&D by nature is expensive and it is a public good. So it is important for the government to take the lead in investing in R&D.
To increase the economic growth potential of the country, we cannot continue to just rely on traditional inputs into production as capital and labor. We also need to develop our expertise in science and technology and innovation so that we can come up with new systems, new ways of doing things.
I think that science, researchers, industry, and even the government is really like an ecosystem of knowledge. So I think it doesn't really matter if you're coming from a private institution or a public institution, such as a state university. I think we all have a role to play to improve the research capabilities and scientific knowledge here in the country. I think it is about time for us to realize that one of our roles as academics, as researchers, as scientists, is to actually contribute to that global body of knowledge.
And the role of this cooperation among these government agencies really is to be able to attract science and technology global-based companies to set up shop here. And that is really key in terms of developing the science and technology innovation ecosystem in the country.
Particularly because there's that deep desire. And what PAASE does and can do more of is to promote this relationship between its members.
We really need to ratchet up the appreciation, the recognition of the importance of science and technology and innovation.
And we are all trying to attain what we call the common good, the greater, higher, long-term good of the Filipino people.
Good morning, everyone. I'm Joel Coelho. I'm a professor of biosystems engineering here at the University of Arizona in Tucson, Arizona. So good morning to everyone in the Philippines, and good afternoon or good evening for everyone here in North America. I'd like to welcome all of you to the Philippine American Academy of Science and Engineering. We are celebrating our 40th anniversary this year, and hence this panel session and this larger symposium. So this is the panel discussion on intellectual property protection and of discoveries and inventions for commercial applications. In our globalized world today, innovation can be considered as its currency. And therefore, it is of utmost importance that every country has mechanisms for protecting these innovations or these inventions and discoveries for their eventual commercial application. And in the Philippines, we are coordinating with the government and other stakeholders, certainly to be able to build its own science and technology-based innovation ecosystem that will create jobs for scientists and engineers, as well, of course, create value and wealth for everyone, for it to be an inclusive endeavor for the development of the country. So once again, welcome to everyone. This morning, we have a panel of distinguished guests that will help us delve into this important topic of intellectual property protection. So we are joined today by Attorney Roel Barba, who is the Director General of the Intellectual Property Office of the Philippines, or IPOPHL. We have Dr. Luis Sison with the University of the Philippines and Director of the Technology Transfer and Business Development Office. We have Attorney Christopher Cruz of De La Salle University, Manila, who's the Manager of the Innovation and Technology Office and Director of the Intellectual Property Office of that university. We have Attorney Marian Ivy De Sena of the Department of Science and Technology. She's the Manager of the Innovation Development Division of the DOST Technology Application and Promotion Institute. We have Dr. Adrian Ibanez, Vice President for Research and Development at Cebu Technological University. And last but not least, we have Dr. Gonzalo Serafica, my colleague at the Philippine American Academy of Science and Engineering, who's currently representing the USAID STRIDE. So again, welcome, distinguished panelists. So the way we're going to structure our program today is we're going to let each one of our panelists give 10-minute introductory presentations. And then after that, we're going to have about an hour of moderated discussion. And of course, we encourage everyone in the audience to please submit your questions or comments through the chat. And then we'll allot about 20 minutes to be able to address your questions by the panel members toward the end of the program. So just one housekeeping reminder, if you could please mute your microphone when you're not speaking so that we have a smooth proceeding this morning. We appreciate your cooperation. So without further ado, let's start with the introductory talks by the panelists. And we will start with Director General Barba.
So if you could kindly, Attorney Barba, share your slides through the share screen.
Yes, thank you very much, Dr. Joel. Esteemed officers and members of the PAASE, distinguished panelists and speakers, my IPOPHL family will help me answer questions later, if any. Fellow workers in government, mga kababayan, isang magandang araw para sa ating lahat. Pau, can you share the slides, please?
Hi, Sir Joel. I'm disabled po. All right, there you go.
Before I proceed, I would like to express my gratitude to Dr. Joel Coelho for the invitation. This morning or today to be a panelist to the PAASE Online Congress 2020. We're grateful for this opportunity given to the Intellectual Property Office of the Philippines to share the different programs and innovations we have implemented over the years to provide timely and quality services to our clients and stakeholders. Please allow me to start with a brief and general picture of IPOPHL services. Even prior to the COVID-19 pandemic, IPOPHL has already adopted electronic filing and processing of patents and trademarks applications. This health crisis added a new dimension to our services that are providing safe services to our clients and employees. We transition to the new normal, founded on one very important element, the optimal use of technology, particularly information communications technology and infrastructure, to serve both our local and foreign stakeholders. In May 2020, we completed the deployment of end-to-end and electronic processing of IP registration and protection services, from online filing and payment until grant for trademarks, inventions, UMs, and IDs. In addition, the electronic systems for mailing of office actions and submission of replies and documents by applicants were fully deployed for the bureaus of trademarks and patents. In addition, we have likewise launched the online system for filing of requests for commercial patent services. Even in the area of IP rights protection, we continue to adopt digital solutions in providing simpler, faster, and safer services. In May 2020, the Bureau of Legal Affairs started an innovation on its proceedings by holding online mediation and hearings to facilitate the adjudication of IP cases. Fully cognizant of IPOPHL's role as enablers of innovation and the need to enhance national competitiveness, we have been steadfast in reducing our turnaround time for IP grants and registrations. In 2013, from 51 months to secure a patent, we have reduced this to 48 months from filing until grant in 2019. This includes the 18 months confidentiality period from filing. For the same period, we were able to cut the ID registration from 8 months to only 5 months, the average in 2019. In 2012, we implemented the express lane registrations for UMs and IDs. For UMs, we have the UM in 2 months from filing date to the recommendation for publication for complete applications with no formality defects. In 2019, 247 UMs under this expedited processing were registered, translating to 25% of total registration of 992. For ID, we have the design in 5 days from filing date to the recommendation for publication, likewise for complete applications with no formality defects. Last year, 452 IDs under this express lane processing were registered, or 32% of total registrations of 1,406. For invention, we introduced an innovation, the issuance of early search report and written opinion in 6 months from filing date. This initiative seeks to enhance the Philippines' competitiveness by facilitating the entry of Philippine inventions to the global patent system. This provides applicants who first file their applications with IPOPHL ample time of 6 months to decide on whether or not they will file an international application under the Patent Cooperation Treaty before the 12-month reglementary period expires. This was inspired by the European Patent Office's practice to assist their applicants. This innovation was awarded by the Development Academy of the Philippines as one of the government best practices, and in 2018 and to date, only the EPO and IPOPHL provide this best practice to applicants. IPOPHL has over the years evolved from a national patent office into an active player in the global patent system. We have signed bilateral agreements with 4 of the 5 biggest IP offices in the world for the patent prosecution highway work sharing that aims to facilitate the patent grant process with the United States Patent and Trademark Office, European Patent Office, Japan Patent Office, and Korean Patent Office for Philippine invention applications filed in these jurisdictions. IPOPHL is also an active player in the ASEAN Patent Examination Program, or the ASPEC, which is the regional patent work sharing program that aims to facilitate the processing of patent application filed across the region. Mga kababayan, we are extremely pleased to inform you of the milestone achievement of IPOPHL. More than 70 years after the Philippine Patent Office was created in 1947, the Philippines was designated as the 23rd International Search and Examining Authority in the world under the PCT by the World Intellectual Property Organization PCT Union Assembly last October 5, 2017. We are the second ISA in Southeast Asia next to Singapore, a recognition of our competence and proficiency to render patent services at par with IP offices in developed countries. On May 19, 2020, we started our operations as an ISA, receiving the first international search report request from UP Manila. This is a critical element in enhancing the country's innovative capacity as it aims to facilitate the entry of Philippine innovations into the global patent system. With IPOPHL offering accessible international patent services to Filipino inventors. Its operations falls into the Philippine Development Plan as the country works towards a knowledge-based economy by adopting an innovation and research strategy to develop a competitive and multidisciplinary workforce, competitive local firms, and public policy environment that ensures innovation. The operation is most opportune as it complements the Philippine Innovation Agenda, which is gaining momentum with the passage of the Philippine Innovation Act. Its operation is a critical element in building a national culture of innovation. Currently, the IPOPHL and the DOST are discussing a memorandum of agreement establishing a mechanism to facilitate the processing and grant of DOST-supported innovations and technologies. To ensure that IPOPHL continues to meet the needs of our clients, our legal infrastructure must be responsive to the demands of the times. We are preparing a proposed bill to amend the IP Code of the Philippines, and among the amendments we intend to introduce is the Provisional Patent application, which is similar to the practice in the USPTO. We think that IPOPHL and PAASE's positions converge on this matter, and we welcome insights and inputs from PAASE to further enhance our draft provisions. Once we file the bill in Congress, we request the support of PAASE for Congress to pass it. Fully understanding that our role as an IP office transcends our regulatory functions, IPOPHL has intensified efforts to support the innovation ecosystem with establishment of a network of innovation and technology support offices, or ITSOs. To date, 100 institutions are part of the network, which consists of 85 higher education institutions, 6 research and development institutions, and 9 support institutions all over the country. The management of the local ITSO network has become a model for other countries to follow suit, that a number of countries from Asia and Africa have visited our country to learn from our experiences. 80 countries have signed up with the WIPO to establish Technology and Innovation Support Centers, or TISCs, in their countries, and there are 898 TISCs worldwide, including our 100 ITSOs, which would make our country as having 10 times more TISCs compared to other countries. The number of IP filings from the ITSOs has increased nearly tenfold since 2014, from 154 to 1,425 in 2018, and ITSOs accounted for over 41 and 45% respectively of all resident patent and UM applications, reflecting the growing innovative capacity of the ITSOs, as well as their interest for IP protection. As partner of WIPO in the project Enabling Innovation Environment to increase the capacity for IP and technology support, a number of HITSAs are mentored on how to commercialize and improve their technologies to be more palatable to potential adopters. In terms of IP technology commercialization, IPOPHL has developed the IP Depot, where IPs or technologies may be posted online, giving technology searchers an opportunity to look for answers to their technology needs. In closing, IPOPHL continues to be a staunch partner and enabler in building a national innovation culture. We have and we will always actively engage different stakeholders, government agencies, educational institutions, organizations such as PAASE and USAID STRIDE, among others, to ensure that we fulfill our mandate of administering an effective IP system. Maraming salamat at magandang araw po sa inyong lahat.
Thank you so very much, Director Barba. Certainly I'm very, very pleased to hear that IPOPHL really is implementing all of these programs that greatly facilitate and help inventors in the Philippines to file their patents. So that is extremely encouraging. And we will definitely discuss this and delve into it deeper during the moderated discussion. Thank you. So our next speaker to give his introduction is Dr. Luis Sison. Again, he is with the University of the Philippines, Director of Technology Transfer and Business Development Office. Dr. Sison, please.
Dr. Sison, we can't hear you.
Dr. Sison, we cannot hear you. We can see you on the screen. However, there's no sound. Could it be that you are muted? You're not.
There we go. Can you hear me now?
Yes. We can hear you now. Thank you.
All right. Okay. Problem with my headset, I think. All right. There we go.
And we can see your slides.
All right. Okay. Sorry for that. So again, good morning, Director General Barba and my colleagues in this field. And thanks also to Joel, Al, and PAASE for giving me this opportunity to share some of our progress and challenges in this area. Joel gave this to us at, when we were invited. So I'll give an update along these three areas of concern. I'll start with the last one, since internally in UP we've had the least the discussion about this. Last Thursday, we talked about our Invention Disclosure Incentive Award for UP researchers and how we passed the halfway mark for quality disclosures, having awarded 58 disclosures out of 98 nominations. And about half of these are still, unfortunately, in the lab stage and have yet to make it to field testing. So similarly, for half of the cases, there is no identified industry partner yet, and we're still working on a path to the market. And this situation is kind of reflected also in our national IP rankings. Unlike in the COVID situation where we are behind our Southeast Asian neighbors, the good news is that we are slightly ahead of some of our neighbors. But overall, we still have some ways to go in terms of commercialization and enforcement, if you look at the encircled section at the bottom. So from this perspective, we need to look at how streamlining the patent process at the very first step may make an impact in terms of the end game, and also how we can help inventors have a clearer articulation and understanding of their value proposition and potential claim set if that optimization is to make an impact. And it's important to look at the process in its totality and benchmark how we're doing in each phase of the process. So on that note, we'd like to share some of the progress we've made in streamlining our own internal processes in UP, and I'm glad Attorney Barba shared how UP Manila was able to avail of your new status as the International Search Agency. So we have had a lot of precedents and established support workflows at different stages of R&D and engagement with industry. And we have also implemented several policy changes to streamline the process internally, including delegating the approving authority from the BOR, as well as shifting the incentives to front load benefits to the inventors and to their home institutions. But more importantly, from an operations perspective, we have a better understanding of the work involved from end to end. So we have been benchmarking the process on some successful cases, and we've come to the conclusion that a single tech transfer officer can complete one case from filing to licensing in less than a quarter, or about 3 months of, if the effort is, continuous, and eliminating all of the external dependencies and delays. This also, of course, assumes that you have these multiple skill sets already on your team. So our goal right now is to provide continuous training to the staff so we can achieve this proximate goal in terms of process efficiency. The challenge, though, is that majority of staff in our offices are still contractual. And while the university is taking steps to regularize our contractuals, we in the tech transfer offices, because we are the youngest offices in the university, are further down the totem pole in this regard. And one consequence of this situation is that we have a relatively young staff also, and we need to continuously do practical on-the-job training on top of what IPOPHL and, for example, Strides KTTO training is able to provide. Which brings up the last issue. Okay, would privatizing the office help? Okay. We started thinking about this actually 4 years ago with Glenn. I'm not sure if Glenn is with us today. With Glenn Baticados, our tech transfer director in Los Baños. At that time, we started looking at different models abroad, from Oxford to D-Star in Thailand, which is interesting because of its focus on the biggest manufacturing sectors in Thailand. We also looked at China, with one tech transfer center being established by the central government. And in the US, TEDCO in Maryland, which was established by the state government. And in general, these organizations provide the following 4 key roles, from advising on IP acquisition and utilization to brokering and mediating agreements, to providing funding and other material resource for these agreements and collaborations. So with that in mind, UPLB proposed One Biotech to spin off its IP and tech transfer operations, providing similar services as to what its counterparts abroad are doing, and then remitting its revenues to UPLB. So we started advising Glenn on this process, and we identified a key step to make this work is for UPLB or UP to grant non-exclusive licenses to this new entity so it can in turn sub-license it to industry. And we also explored several sustainability options that fit in with our current legal framework, particularly for procurement and outsourcing of services. And the first and least desirable is to have One Biotech compensated as consultants. But much less complicated is to negotiate a fixed royalty rate for One Biotech on top of the royalty rate that they're able to negotiate for the university. And one last variation, what is slightly more complicated, is to have this additional rate negotiated on a case-to-case basis. For us, it was clear that option B seemed to be the simplest model to achieve our overall objectives. So the bottom line, after all of that work, is the key issue is how do you get this started? How do you get it funded? And that's where we got stuck, actually. So we're hoping that the discussion today may give us more insights and help us provide more leads to maybe get this moving forward again. So thanks again for this opportunity to share with you what we're working on. And we're also currently developing a formal practical training program for our own staff and eventually for other universities as well, building on the training provided by IPOPHL and Stride in order to address the bottlenecks that we have experienced. So let me know if you're interested. I'll be happy to entertain your questions after the panel intros. And again, magandang umaga sa inyo lahat.
Thank you very much, Dr. Susan. Quite informative. We will definitely discuss this in the moderated discussion. So our next panelist to give an introductory talk is Attorney Christopher Cruz of De La Salle University. He's again the manager of the university's Innovation and Technology Office, as well as director of the Intellectual Property Office. All right, you have the floor. Attorney Cruz.
Thank you, Dr. Joel, and to the PAASE organization. Good morning to everyone. Magandang umaga po. So my introduction for this morning will be on the perspective of a private university, and how we do it, how we do patent or IP protection and commercialization. So at first, I want to give you a very short backgrounder of the tech transfer ecosystem in the Philippines. So we all know the IP code, RA 8293, and the amendment thereto, which is 10372, which mandates all schools and universities to adopt IP policies. I am happy to say that LaSalle had its IP policies way back in 2004. And amended in 2008. And actually right now we are revising it to make it responsive to the times. So immediately thereafter, sometime in 2009, we had the tech transfer law, which is the equivalent of the Bayh-Dole Act in the US, where the principal feature would be that the IP ownership would now belong to the university or the RDI, and the purpose is to facilitate transfer and promotion of commercialization of research outputs. Now, at present, this is from the perspective of the LSU. This is the support ecosystem that we receive for IP management and tech commercialization. As mentioned by Director Barba a while ago, we are the part of the original member way back in 2011 of the ITSO, or the Innovation and Technology Support Offices. We are very grateful for the support it has given to us, both in training, and being the channel for collaboration with other universities. As mentioned also, we are supported as well by USAID Stride and the DOST, the KTTO, or the Technology Transfer Office. So we see that the ITSO and the KTTO are the same. You may call it either the ITSO or the KTTO, but for as long as you function as an IP office or a tech transfer office, then that would suffice. We have also support coming from incubators, accelerators, fab labs in universities. So the tech transfer discipline is being ably supported by these other activities, and capacity building programs for researchers and technology transfer professionals. I mentioned here ATOP because we are now in the process of organizing an alliance of tech transfer professionals in the Philippines. This is similar to the AUTM in the United States. And I'm proud to and happy to say also that this is being supported by WIPO, or the World Intellectual Property Organization. It is now supporting at least 4 countries. And again, I'm happy to say that of the 4 countries, they look at the Philippines as the model for the ATOP, no, or for the Tech Transfer Professional Organization. Of course, we are very grateful for the funding coming from government, like the Impact, Fast Track, Cradle. No, these are the coming from specifically from DOST. In fact, DLSU is a grantee of the Impact program, capacitating the Tech Transfer Office, and we've just finished, no, the program, and very soon we will be embarking into another challenge, which is to be the commercialization hub of IBET. No, IBET is the Institute of Biomedical Engineering and Health Technologies in the Philippines. Now, DLSU has been recognized as the National Institute for Biomedical through the IBET, and our office was tasked not to be the commercialization hub. Challenges for Philippine universities. I think this is echoed by most ITSOs and KTTOs. The capacity building. We lack the people who will do the work for the ITSO. And so we're very grateful for the grants, no, that we receive, because we're able to hire people to do the job. The usual hybrid, no, the evolving hybrid between the researcher being tasked to do commercialization, no, so from publish or perish to patenting and commercializing. Still, this is a challenge to our university, but I am happy that we are now gaining more IP champions to this, no, activity. Need for policies and procedures for doing this. Aside from the IP policy, we are now looking at the tech transfer protocol or tech transfer policy, which is separate from the IP policy, because this would now include the commercialization part, because the IP policy does not really cater, no, to that. So just a brief snapshot of what we do in the university. We have 2 internal offices, no, the DLSU IP office, which is in charge with the internal affairs, IP management, IP awareness, and licensing, and the DLSU Innovation and Technology Office, which is considered our ITSO, which is the Tech Transfer Office. No, at present, I am both the director and manager of these 2 offices. And the third part of the ecosystem is the Animo Labs, no, Foundation Incorporated. One unique feature of this is that this is not part of the university, but a separate entity. It has its own board. It has its own officers, so that we can act faster, no, than going through all the processes in the university. So Animo Labs is wholly owned by DLSU. And we're happy to say, no, that we are one of the first universities that have 2 student organizations. We have the IPA, and I think IPOPHL was recognized this, no, that we were one of the first universities to have a student org. And Unboxed, no, IPA is more on IP awareness and IP management. Unboxed is a student organization for tech transfer and commercialization. So this corresponds to the 2 offices in the university. And again, another unique feature that we have is that we have the DIG, no? We call it the DIG, the De La Salle Innovation Group, where we invite all the colleges, and this is what is unique about this. We invite all the deans, no, and the research center directors into this group, and this is chaired by the manager of the DITO, or the Innovation Office, no? So and Animo Labs is also a member of this. This is the venue we do at least once a term, where we share innovation practices coming from all the colleges so that we can synthesize our activities. Our network, I'm again proud to say that this network was created through the DITO office itself. So we have MOU with the IPOPHL. We have an upcoming MOU with WIPO. We have of course, through IPOPHL, we were able to talk to the WIPO Academy for possible support for our masters in innovation and intellectual property management, and all of the others here, USAID, AUTM, Oxentia, and through the LIF Slipstream. Our activities involve the yearly DTech Fair, where we exhibit all our inventions and innovations. We have done this since 2012. We have IP forums. The picture here shows one with SAPI, or the semiconductor industry of the Philippines. And we were able to have a publication through the AREA, or the Economic Research Institute for the ASEAN, out of this focus group discussion. We have IP clinics. We have tech assessments, which is part of our impact program. We have workshops, design thinking, technology transfer. So let me go directly here. Why do we file patents? Because we want to demonstrate that our research is relevant to industry. We want to create opportunities for tech transfer and innovation, and we want to create an IP portfolio. Very briefly, this is our patenting process. From the depot, we schedule an IP clinic. We do a search report. We after that, we make a recommendation. If positive, we draft the patent application and then file it with IPOPHL. And that is done for all the disclosures that we receive. So some learnings is that we want the researchers to really go to us, consult us, and that has been happening because of our increasing IP awareness. And that we learned that this is really a collaborative process. The team is very important. Without the research team, it would be difficult for us to do IP management. And that patent prosecution takes time. And I'm happy with the information from Director Barba, that they have improved on the time to grant the patent application. So for the tech transfer, this is different. A licensee goes to us, usually a researcher who wants to do a spin-off, submits a proposal, we submit a term sheet, we negotiate, and then we will have a licensing agreement. So in numbers, just a snapshot, we have 26 pending patent applications with IPOPHL, 2 PCT applications, 2 granted patents, 4 UMs, and 2 registered UMs. So moving ahead, I think there is still a lot of challenges. We continue to capacitate ourselves, and as we do that, we seek the help of everyone in the IP management ecosystem in the Philippines. Thank you, and we'll be ready to answer some questions in the question and answer.
Thank you so much, Attorney Cruz. That's very informative indeed, and we will discuss them in the moderated discussion. Before I call on Attorney Marian Vicena, I thought that why don't we call Dr. Adrian Ibanez first, since he's also representing a university. So let's group all the universities together. Our next panelist for the introductory talk is Dr. Adrian Ibanez. Again, he's the Vice President for Research and Development at Cebu Technological University. Dr. Ibanez, the floor is yours.
Okay, good morning to everyone. I hope you can see my slides. Okay, so good morning once again, and thank you very much for the opportunity to Dr. Pelio and also Dr. Al. Good morning again to everyone. So my presentation is a bit from a young university, and probably representing most of the perspective of SUCs other than UP in the country. I'd like to share with you some of our challenges at CTU here and at Cebu. I'm currently handling the research and development. So just to give you a background of CTU, it's an ISO certified public education institution. It has actually 23 campuses all over the Cebu Island with around 40,000 students. It's probably the second largest SUC outside of UP. And because of it's widely distributed, it represents different settings from rural to suburban to urban settings. So probably representing very much the same picture with several other SUCs in the country. As I've mentioned earlier, a bit of a young university, just been converted last 2009. So we're very, very young in terms of being a university. Now, however, CTU is the only technological university in the Visayas and Mindanao with an SUC level 4 recognition. It's been recognized also by the APOPHL as the top SUC with the most accredited programs in 2018 and 19. Thus far, we have received around just more than 300 million grants in the last 3 to 4 years, and we were very happy that we are also one of the DOST NICER program recipient in one of our campuses in Argao. So DPI also supported us, and I think we're the SUC with the most Fab Labs and SSF in Visayas and Mindanao. And I think IPOPHL is listening, so we thank them for recognizing us, for having filed the most number of utility models from 1998 to 2017 in the category of academic institution. And just to take note and emphasize, even before, we don't have an ITSO. So we just formally had an ITSO last year. So we were able to still get that recognition. So we thank IPOPHL for recognizing that. Now, I just go direct to the objectives, and we were asked to talk about the processes and what are the key challenges. So we do believe that the key enabler for a Philippine institution is really, it starts with the top management support. Previously, we had some really tough challenges, but with our management support right now, who is really gearing towards technology and innovation. So I think the best to do for Philippine institution is to first have the management be on board, that they do recognize how important these innovations are. And then we have the presence of grants and support, although some SUCs are complaining that there can be no funds, this and that. I think there are funds, but there are not just much proposals being submitted from different SUCs. So I think that the presence of these grant support would truly help unless we don't want to access it, and I think that would be contrary to what we're saying. We do have the local scientists available, and there are many scientific and professional organizations, to mention NRCP, OYS, PAASE, UC Stride, IRIS, many others who are really geared towards helping innovation progress in the country. And of course, we have the IPOPHL who is with us and one with us in having the intellectual property rights protection. So what are the key challenges so far that we have encountered at CTU? And it is very common. None of the private universities, even UP mentioned this. The first is really on the relevance of these outputs to the career of the faculty. While probably UP is looking at it that it's much dealing with promotion, and in SUCs, it's really just one of the aspects of promotion. They can get promoted even if they don't do so much research. So some doesn't see the relevance of putting so much innovation. They can get still promoted until an associate professor. It becomes critical when you go into a professor rank. As of this time, although they are revising it, you only need one publication to actually become a professor in the Philippines. So it's quite a big difference at the UP system. Another is on patents and utility models. It takes a long time to really go for patents than utility models. The applications is very tedious. The points, the way we are allocating it is almost the same. So the mentality for faculty researchers, why would they go for patents if they could get it much faster if they go for utility models? So most would tend to go to utility models and get the points because, in the ranking for us SUCs, it's every 3 years. So we have a cut-off time on how with these points. And then unfortunately, well, I do appreciate Dr. Barbara mentioning about, and we want and really want to avail of those services. Even at this time, we have received a lot of delayed responses or applications, and we ourselves are being shocked that we given like few days notice that our application is going to be withdrawn. So I'm not sure how this works. Maybe it's a prayer. I'm not sure about it, but we're trying to negotiate on how we can do things better with IPOPHL. But that's one of our concerns and how we are doing it with them. Another key challenge is the equipment and doing the innovation. And it's the same, I think, all throughout the SOCs in the country. And there's a reluctance to disclose. Some of our innovators feel that since the process is quite tedious going for intellectual property rights protection, they'd rather have it or make a business of it on their own. So they're reluctant to give it to us. And then we do lack some staff in doing all these works. As a young office in terms of the intellectual property rights protection, so we do need a lot of staff. And as I mentioned earlier, also by our colleague from UP, also that most of our staff are also in a way contractual in nature. So another key challenge we've noticed is that innovators may not be good writers; they just want to innovate. But when we give them the task to write proposals, to do the IP application, it becomes very challenging for them, and some will just stop in the middle of the way and say, forget it. So that's something that we need to look into and how we really encourage them to write. Because IP application takes time and practice. And since they are very used, like in our case, our faculty, while we encourage them to go into patents, they've been used to doing all of this into utility models that they're doing for patents. Some are really good for patent, but they still prefer to go to utility models. So there's a lot for them to unlearn, and not just about innovation, but of how they're doing things, because they are very good technically. They don't want to go to innovate anymore because, as I've said, the promotion on the SUC's perspective are not yet heavy in terms of research. It's heavy in research, but it's not the only way by which we can get promoted. Let me correct the statement. Then our technology adapters are mainly the community and not the industry. But it is encouraged, and it's probably maybe due to the usual requirements of CHED going for extension. They do not, while they say that the industry linkage is very much encouraged, but there are no specific mechanics on how many industries or what is. We just come into across of how important is this when we were made by CHED to go into the QS ranking, and we've seen a lot of how challenging it is looking at the TBIs, the spin-off companies, and that CHED has more information on what we need to accomplish. But as it stands, when we look at the SEC ranking, there's not much emphasis on this one. It's only a small fraction of the requirement, the way I would see that. But the QS is really very heavy in terms of trying to accomplish the linkages with the industry. So we thank CHED for giving us that opportunity, and it's really challenging for us to comply with that one. Then we have these innovators and researchers. Also, they are not usually business-minded, and we're trying to promote them, to promote the idea of having the innovations and then research being really put into the business sense, and takes a lot of time for us to train them. And some lack the understanding of sharing the mechanics. The mechanics of sharing if they do go into the licensing. So the process is quite tedious for most researchers on how we do the transfer of the technology. And so we tend to just give it up. As I've talked with Doc Al before, sometimes because our target is really helping the community, not so much yet on the business side. So we tend to just give the technology for free to the community. So it is one of the advocacies also for the community extension part of the SUC. And then some of our target local recipient industry can be unfamiliar. So we do have some recipient industries locally. I did not to mention this one. Or maybe they're taking advantage because we're not familiar with it, or they're not familiar with it. So sometimes there's not much clear cut on how the selling goes through. And even regionally, I'm a member also of the Fairness Opinion Board being created by DOST, and hopefully we get used to that. We're still trying to look at how the technology would really be licensed and be connected with the industry. So this is our, at least in our perspective, key recommendations. Really, the top management support must be secured. In our case, I'm very thankful the president is really a visionary in terms of how he leads our university going to that direction. And there should be a better incentive scheme or recognition by the government to encourage more researchers and interested faculty to engage more in these innovations. And time to conduct these things is non-negotiable. I think everybody should know the Philippines that we have this, for most SOCs, 18 to 24 units load, and we have to insert the time for research. And it depends on each university, but it's been some of the concerns how faculty researchers are going to be deloaded, or at least given workload equivalents to do some form of research. So that needs to be negotiated as well. Although at our university, we're working on that. And then we have this, the capability building is going to be very necessary. It was also mentioned earlier about the trainings, even the writing is very important. And then the assistance in the product commercialization is going to be very important. And then the linkages with universities, and of course, the IPOPHL, and we would be very much appreciate if we could receive the notices through electronic means other than the courier, which might get delayed. Although we have already attempted also using the innovation being introduced earlier by Dr. Barba using the online means. So thank you very much, and good morning.
Thank you very much, Dr. Ibanez. That is quite informative. And again, we'll talk about that during the moderated discussion. So now I'd like to welcome Attorney Marian Ivy Disana. She's again with the Department of Science and Technology, and she's the manager of the Invention Development Division. The floor is yours, Attorney Disana.
Thank you so much, Joel. Can you see my slides now? Okay.
Yes, we can.
Okay. To our distinguished panelists, members of the PAASE, ladies and gentlemen, good morning. Of course, I wish to thank the organizers for giving me this chance to share what we do in TAPI in terms of IP and commercialization. My topic for this morning will delve on the gaps, opportunities, and lessons learned by TAPI throughout the years. So the Technology Application and Promotion Institute is a service agency of the Department of Science and Technology, which is the central authority that provides direction, leadership, and coordination of scientific and technological effort. TAPI's primary mandate is to serve as a commercialization arm of the department, promote the technologies generated by it, and market the services of our other operating units. TAPI was created in 1987 with the passage of Executive Order 128, reorganizing the National Science and Technology Authority. However, our Intellectual Property Rights Assistance Program only started in 1992 with the passage of a legislation mandating the grants of incentives to inventors. The initial objective of the program is to provide technical and financial support to Filipino inventors in the protection of their inventions and innovations. The program specifically caters to the need of private individual inventors. After 17 years, another law was enacted, which impacted how we implement the program in a sense that it now mandates institutions with government-funded researches to protect their intellectual properties. Further, the law delineates ownership over IPs generated by government-funded R&D and provide mechanisms or protocol on how to go about its commercialization. In response to that call, our IPRA program has to evolve and make several reforms to include institutions that receives R&D funding from the government and not just private individuals. And it further expanded its coverage to other types of IP assets which are critical to commercialization. At present, this is the current framework of assistance of IP that we implement in TAPI. Now, there are various players with variety of IPs that we are catering. With this kind of framework, could you say that we are on the right track? Let us look on some historical data to answer this question. In terms of IP applications assisted by TAPI, you can look at the trends as regards our performance. As you can see, there were dismal filings in the 90s, and this significantly increased in the succeeding years with the reforms made in our IP program. In terms of the Philippine performance in the Global Innovation Index, there is an improvement in our ranking from the 66th spot in 2007 to 54th spot in 2019. As we all know, one of the pillars in competitiveness is knowledge and technology outputs, which can be impacted by the numbers of IPs that the country is producing. In terms of commercialization, R&D efforts are no longer confined in publications, but is venturing in the market as evidenced by more researchers directly pursuing commercialization, not only locally, but internationally. Right now, we are already assisting PCT applications, also national entry phase application in targeted countries. With all of this, what lessons in the road did we learn? Here are some of my key takeaways in our journey in reforming our IPRA program. First, there's a need to enact a responsive legislation that will address the gaps in the local landscape, particularly those that are specific to the psyche and the dynamics at the local level. Likewise, this has to be supplemented by information drive to educate stakeholders. Likewise, we also need to instill awareness and appreciation on the benefits of intellectual property protection, IP protection vis-a-vis commercialization, and how it translates to overall competitiveness of the economy and upliftment of the country's competitiveness. We also need to intensify technology transfer programs by allocating sufficient budget for implementation of various activities. In our case, we have to source out other available funding platforms. We also need to capacitate relevant stakeholders in areas of IP protection, particularly in prior art, drafting, and filing, in order to address skills gaps and lack of competent and capable IP professionals. We also need to deepen and widen network, partnership, and linkages to other key players in the IP innovation and commercialization ecosystem in order to promote meaningful collaboration for mutual benefits in the delivery of IP services. We also need to pursue international trainings in order to assess countries' performance and benchmark best practices in its fields that could be adapted in the local context. And lastly, our very own Intellectual Property Rights Assistance Program Unit has to innovate in order to meet challenging demands of our clients, focusing on how to efficiently provide its services. Despite of this, we know we still have some room for improvements at a macro perspective, and the following are the areas of opportunities that we could consider. First, we need to augment plantilla position to better address increasing demands. Second, we also need to improve the IP infrastructure and allow better coverages for our IP packages. Third, we need to incentivize in-house IP specialists who performs IP services which are beyond their regular duties. Fourth, we need to strengthen partnership and dialogue with our IPO office. And lastly, we believe that it's time that we pursue IP enforcement. So in conclusion, our experience in complementing IP program has given us valuable lesson in the types of reforms that we have to pursue and the strategies that we have to implement to achieve our goals. As highlighted in the key takeaways that I have discussed, with special emphasis in the need for further legislation that will serve as a catalyst for meaningful improvements. However, let me emphasize that these lessons are built on our own experience, inherent with the sociocultural context of our country. Hence, some recommendations may not be totally applicable in your own context. Nevertheless, these lessons are very instrumental in how we perform today. At present, we still have areas and opportunities for improvements, and we hope to learn not only from our own experience but also from the experience of other countries. That is why we aim for strengthened partnership and welcome collaborations. For that, you may reach me at the following contact details. Ladies and gentlemen, this concludes my presentation on the dynamics of IPR landscape in the Philippines, DOST TAPI perspective on gaps, opportunities, and lessons learned. Once again, this is Attorney Marian Ivy Dicena of the Invention Development Division of DOST TAPI, and I thank you for your attention.
Thank you very much, Attorney Dicena. Very informative indeed. We're going to discuss this again during the moderated discussion. And last but not least, I'd like to call on my colleague, Dr. Gonzalo Serafica, who is currently with the USAID Stride. Al.
Hello, everyone. Can you hear me? Can you see me and can you hear me?
Yes, we can. We can hear you and we can see your slides.
Okay, thank you. Yes, when we organized, when Joel talked about organizing this session, I really wanted to have representatives, of course, from the universities, which is the main generator of IP. And of course, DOST being the RDIs as well, because I was a balik scientist with them. But as I go through the presentations, I decided maybe I can paint the picture on what happened to me first before I showed up in the picture. This is where I came back to the Philippines in 2013 to be a balik scientist. But before that, I was an IP practitioner. I was a customer for that matter. So I decided, why don't I summarize what happened to me before I came here? And that's what it's in this slide. Clearly, I filed my first application as a graduate student in a university in 1995, and it was assigned to my university. At that point, this was already a very fork in the road for me because I could have decided to file it myself. And when I give talks nowadays, I keep telling inventors and scientists to file it with your university because it lends your invention some credibility as well and the support of the offices. So it happened to me 25 years ago, and I can't emphasize it more that you can't do it alone, even in IP. So the following year after my filing, I ended up starting a company, a real spin-off with an alumni of the university. And that's because we met in a IP forum, not much different from this. He saw my invention and he said, I want to invest in that one, Al. So he put up his own $250,000 to start the company. And I brought in a small business innovative research grant from NIH for our first product at that point for $100,000. And within a year, we raised $1 million. So it was a very nice experience for me. But at the same time, there was some additional information that not a lot of people know. That after we started the company, we found I knew the patents of Johnson & Johnson were available and not being used because we talked to their lawyer who happens to be an alumni again of the university. This is where your alumni network helps. And so we ended up licensing the granted patents of Johnson & Johnson and my technology. This is a reverse licensing. If you think about it, typically it's the big companies that license from small companies. In this case, it's probably the first ones wherein the big boys gave it to us because I had the technology and the capability to produce, and they were not exploring it at that point in 97. And that actually helped us raise our first venture capital for $1 million in 97. So fast forward to 1999, after I filed the first patent in 95 under RPI, we had a divisional and filed a second patent after we got our patent grant in 99. So the divisional got awarded in 2001. So roughly at that point in time, the USPTO was doing about a 4-year track in terms of filing to granting. And we had, of course, applied for PCTs for those as well. But because of the available patents of Johnson & Johnson, I didn't have to file my own developmental patents for my company until those patents were about to expire. So it gave me a runway of about 6 years to file my first wound dressing patent. This is on treating chronic wounds. It's an artificial skin for diabetic ulcers and pressure sores. And we didn't file that until 2002. And by the time the company was fully grown, at maybe about 10 years old, I managed about 66 patents. And 12 of them are about 12 provisionals.
Tapos na lang, pero may question and answer pa ito.
Excuse me. Excuse me.
Oh, matagal pa to.
Excuse me.
Nagre-relax na ako sa studio. Dahil tingnan mo yun.
Excuse me, whoever mic is that one, please. Okay. So there. I'm one little company with 14 employees, and I had 66 patents in my portfolio. We got about 10 US granted patents and about more than 20 international patents. So that's for one individual in America. So by the time I sold my business, 80% of the value of the business were affixed to the IP. That's how valuable IP was, at least in the United States. So then I retired, ran car races for a year, and then I decided to come back to the Philippines in 2013. Next slide, please. Next slide, please. There. So I became a balik scientist. There. And so I looked at the portfolio of the UST. I also advised startups. And of course, I was a consultant for UP System and DLSU as well. And I'm so happy that Chris and listening to Chris and Louis really shows the depth and the sophistication of the two IP systems in both universities. I'm very happy to be a part of that as well. But the ones that I never discussed is the involvement with a private institution. I had managed a startup, unfortunately, because of confidentiality, I can't get to know much details. But I helped them file a US patent application in 2013 with the help of my law firm in the US that I work with. It's Foley and Lardner. They file about 11,000 patents a year. So with their assistance, we were able to get a grant within 3 years of the technology that this startup was developing in the Philippines. We had then a divisional on that patent and filed it in 2016, and we granted that second US patent for this Filipino in 2019. So at that time also, again, Louis has already talked about the university disclosures that we have been wanting to increase, and it has. We're still trying to get to the 100 number, but we're getting there because we're very critical about we only approve ones that have potential for economic value and industrial applications as well, and real inventiveness and reduction to practice. So in DLSU, of course, I mean, Chris already mentioned some of the filings that's happening there. And part of the reason that I wanted Adrian is I visited CTU last year under IRIS, and I found them to be the highest filer awarded by IPOPHL, and I wanted him to show what it's like outside of Manila, being the most awarded already outside of Manila, and you can see about how much needs and wants he still has. So, and again, part of the challenges for us is really, I've seen some spin-off happening in UP recently in the last 3 years, starting with MTech, the one that made your diagnostic kit for dengue. And that's our first spin-off in UP. And of course, there were some efforts with IPOPHL under Rick Blancaflorpa for FDA for facilitating approval of local IP inventions, which we initiated, I think 2016, 2017, before he left IPOPHL and Josephine Santiago took over. So this is what I saw when I came here. And clearly, 7 years later, that's my last slide, please. Here are some of my wishes still. And again, I hope that not only UP and LaSalle, but all the ITSOs, Director General Varva, to have this capability of disclosing with some expert opinions supported, as you already suggested in your early search reports capability now at IPOPHL. Also, the increase in patent applications, again, less UMs and more full applications that have potential worldwide capability in filing PCTs. Of course, securitize it with a provisional already. That's already been on deck for quite some time. Again, I was a practitioner of provisional patents before I file a full application so that I can not only reduce it to practice but support it with data to increase patentability of the application. And of course, licenses that would lead to spin-off companies that would lead up to funding support. The UST has been very aggressive as well. I've been asking for a small business innovative research grant, which I received in 1997, to be mimicked here to create that similar environment. And DOST with under USAC GEB, and at that time it's USAC AMI as well, has responded very good on fast track and technicoms. And of course, again, I'm not speaking as wholly as USAID Stride, but USAID Stride has been around also for about 7 years, and we've been very aggressive in government, university, industry, research roundtable activities, increasing. Even we've developed the, I think if Richard is in the audience, he was the developer for the Aguila Awards, where we had LaSalle and IMI together developing research, which one of the first ones in the country at that time, where actually a private institution provided full support and funding. So this has became the DOST Cradle as well. That's now being adopted, as well as the Business Innovative Loan, which I still wish it was a grant. And of course, DTI has, with the Innovation Act, has also wanting to get involved in the innovation ecosystem. And I'm hoping my last one would be DA, because of the agricultural needs of the country. I know they support a lot of work under UPLB and CIARCA, but I talked to Glenn Gregorio, who's a fellow NAST member, and he said that clearly this an area, technology commercialization and agriculture, should be a must. And of course, the last but not the least, we brought in ICOR under USAID and LaSalle and DOST. This is the team training of technologies to become commercial with the help of an industry mentor, an inventor, and a tech transfer officer. It's called Filipino Innovation Entrepreneurship Corps. It's patterned at the US ICOR. We have done 2 cohorts since 2018, twice in LaSalle under the College of Business School, Dean Emmy. But we brought in instructors from George Washington University, who's an ICOR certified instructor in the USA, to help in the training. And DOST owns most of the materials as well, and about 10 of their technologies were part of this program, as well as UP, LaSalle, and Mapua, and UST. So we've started, and there's just indeed the beginning, and I'm hoping that we'll have a lively discussion moving forward based on this initial suggestion. I think that's all I have, Joel. Thank you very much again for being here, all the panelists, and well as helping us in PAASE to be able to advance the IP and the R&D commercialization. Thank you.
Thank you very much, Dr. Serafica. That's a very inspirational background that you provided to us in terms of your personal experience. And certainly the dream and the vision and the goal here is to establish the innovation ecosystem in the Philippines, including, of course, the IP ecosystem, to the point that scientists and engineers in the Philippines will be able to do the same thing that you did here in the United States when you were here. So thank you for that inspirational introductory talk. So now we go to the moderated discussion, and essentially I'll be asking questions to some of the speakers, but we're going to divide our discussion into 2 parts. The first one is focused on the IP application process, and then later on we're going to talk about the IP management, technology transfer, and commercialization. So I want to talk to you first, Director Barba, if you will. So I just want to make sure that I got my numbers correctly, because you mentioned this actually in your talk. In 2018, did I get the number correctly that there were 1,245 patent filings with IPOPHL? Is that correct?
That's 2018?
Yes, 2018. Was it about 1,200 or so?
Yes, I think so. Yes.
Okay. So, of course, these patent applications are still currently being prosecuted, so there is no outcome yet.
Mhm.
But can you tell us, in general, who filed these patents? In other words, were they universities? Were they private companies? Who are these patent filers to IPOPHL?
Well, currently we're still working on more filings locally, but I think for the patent applications, we still have more applications from abroad. Maybe Director Beth of Medrano of our Bureau of Patents can give clarification.
Okay.
Director Beth.
Yes. Thank you, DG. Good morning, Dr. Joel and all the panelists and participants of this online Congress. We thank PAASE for giving us this opportunity to explain more about the IP system. On the average, we usually get around 3,600 to about 4,000 applications a year for patents. And that would most well, based on historical data, 90% of which would be foreign applications and about 10% would be local applications. On your question as to whether what type of local applications are we getting, we're getting a mix of institutional filings from our ITSO members and universities. And then we also have individual invention applications from individual inventors. And then we also have corporate filings from local companies. But as DG Barba has mentioned, for the recent years, about 45 to 50% of the local filings are coming from our ITSO members.
Okay. Thank you, Director Beth, for that very illuminating statistics you just shared to us. So you mentioned that 90% of the filers are foreign. I suppose these are foreign companies. Can you kind of elucidate on that a little bit more for us, who these foreign entities are?
For foreign filings, that would mostly be PCT applications, and that would mostly be corporate filings. And then we also have individual foreign applicants.
And do you happen to know if these foreign filings are essentially corporations with operations in the Philippines?
Yes, that's right.
Okay. Well, that is actually, a very good piece of information for me because I didn't know that before. But that goes to show that the Philippines really is attracting a lot of these global companies to do certain of their functions here in the Philippines. And I would guess that predominantly that would be in the manufacturing sector. And that is why they're filing these patent applications or protection of their intellectual property in the Philippines so that their inventions remain protected while operating here in the Philippines. So that is actually a very positive piece of information I got from you. Thank you very much. So back to you, Attorney Barba. Can you explain a little bit more to us this express lane registration? And you said that that takes about 2 months.
Yes.
So what happens? What happens after the end of the registration? Does that mean that the inventor is free to make any public disclosure of the invention after it's registered? Or please explain that to us.
Well, yes, for I earlier stated that we can now get it in 2 months, provided all the documents, all the requirements have been submitted, and ID for 5 days. From 40 to 20 months earlier in 2013. And I would also like to take this opportunity, Dr. Joel, that about the concern of Dr. Adrian earlier on the difficulty of filing a patent. Part of our amendments to the IP code is to allow parallel filing for patents and UMs. And under that proposal, one can get a UM in the meantime. Then after prosecuting the patent, if it's allowed, then we can just cancel the UM. So that's
Okay,
part of the
just for clarity for everyone, stands for
utility
utility.
model.
All right,
Yes.
very good. Okay, thank
Yes.
you.
So that's we are now allowing. That's part of the proposed amendments, which also includes the provisional patent application. And to assist our inventors enter the global market, we are waiving until next year the search fee for the PCT. If the Philippines, for Philippine inventions, if the Philippines will be the ISA. So that translates about $600 for small entities and about US 1,500 for big entities. So that's
All
part of
right. Okay.
our initiatives to assist our local inventors, scientists to enter the global market.
Yes, correct. Yes. So now, Attorney Barbara, about the training of your patent examiners. First of all, how many patent examiners does IPOPHL have, and how do they get trained?
I think we have right now about 100 patent examiners, and we have a pending application with the DBM for more plantilla positions. We have a problem just like the DOST. We lack regular positions for this our staff. So hopefully we'll be able to get the approval of the DBM in the soonest possible time. And most of the trainings we get from our bilateral partners, the WIPO, uh, J Japan Patent Office, and the Korean Patent Office. They're our generous partners in providing training to our examiners.
Okay, and DBM, of course, is the Department of
Of budget
Budget
and
and Management.
management. Sorry for that.
Correct. Yes. All right. And now you said that you have about 100 patent examiners. As of now, do you think that's an adequate number, or it seems to me that you need more, or that's what I'm reading. So tell us.
Yes, we sought additional, I think, 192 additional plantilla positions, and hopefully we'll be able to get the approval in the soonest possible time because we will be needing them, hard bodies, especially if we will go full blast for our ISA.
Okay. So you're going to request for another 200. So that's going to be a total of about 300 patent examiners, right?
Yeah.
So you mentioned that now you've been able to reduce the patent prosecution to about 48 months. Are you able to do that with just 100 patent examiners currently?
Well, currently, I think we're able to do it, but we will not stop there. Hopefully, we'll be able to at least lessen the turnaround time. That's part
Correct.
of my agenda for the next 5 years.
Right, right. So with the additional patent examiners, about 200, so you have 300, you'll be able to further reduce the prosecution time for your patent.
Yes.
So like
And
how many years you think? Do you think 3 years or less than 3 years?
I'll ask Director Beth to answer that.
Okay. Sure, yes, that's fair.
Director Beth.
Okay. Well, of course, we all know that there's the 18-month confidentiality period, that so that you tap that in the entire processing period. But we're trying to benchmark with other IP offices in the region. Actually, we're one of the fastest already in ASEAN in terms of patent grant and processing. But of course, we continue to push the envelope further. And with DG Barba's direction of further streamlining our processes, we're actually looking at other matrices. So we're looking at pegging the turnaround time reckoned from the date of substantive request for substantive examination rather than the filing date. So we're constantly reviewing the matrices, but 48 months is it's still not good enough for us.
Right. So what is your goal?
Well, perhaps 45, but we're also looking the vicinity of 35 months from the request for substantive examination.
Okay, all right. So Director Bett, since you're already online here, I just want to be clear about this. You mentioned that there's, of course, an 18 months confidentiality period. I'm just trying to jibe that whether that's related to the express lane registration of 2 months for utility models or patents. So even after the registration is accomplished using the express lane for 2 months, the confidentiality period is still required, correct? Still applies.
Okay, all right. Let me first probably cite the non-disclosure provision under the IP code. So any disclosure made by the inventor or the applicant 12 months prior to the filing date will not be considered prior art, or will not destroy the novelty. Okay. And then we have the 18 months confidentiality period under the PCT. So that's for patents. But for industrial design and utility models, the confidentiality period is from the time of filing until the time of publication. Okay, so that means that for utility model, if they're going through the in 2 months track, so that would mean that 2 months there's a grant of the utility model from within 2 months. So that would mean from the date of filing until the date for recommendation for publication, because under Philippine law, the date of publication is the date of registration.
Got it.
Okay.
But I just want to be, I just want to clarify something here so that particularly those faculty members at universities that are concerned about publishing their findings or their invention, when is it safe for them to publish or to make public disclosures of their inventions after filing their patent? So we're talking about patents here. Let's focus on patents.
Okay. So for patents, yeah, the 8. So you actually have they can actually what we usually recommend would be to to assess the readiness of the filing of the application, such that you can actually disclose or publish your research and studies as long as you file the application within 1 year from the date of publication or disclosure.
Right. Oh, so that in the Philippines, that is allowed?
Yes, that is allowed. So we have the non-prejudicial disclosure under the IP code of the Philippines.
That is very interesting. So in other words, if I'm a professor at a university in the Philippines, I have my invention, I can make that public, disclose it publicly through seminars or publications, papers, and I have up to 1 year to file for a patent to protect that invention. Did I get that correct?
That's right, as long as you file it within 12 months from the date of disclosure.
However, that exposes my invention for potential intellectual theft by others, and perhaps from other countries as well.
Yeah, I think that's always, that's always a risk that that we have to take. So it's probably a sound judgment of the inventor, the researcher, and probably the university or the institution. And I would suppose there are certain policies on disclosures of faculty researches or university staff, study grants or researchers for that matter. So I guess it's a matter of balancing, the advantages and disadvantages of having an early disclosure.
Okay. Thank you so very much. Thank you. Yes. And thank you, Attorney Barba. We'll get back to you. I'm going to move on now to the other panelists. And I want to talk with Dr. Let's see, sorry. Susan, of course, from UP. So can you tell us about how you came up with your IP policy at the university?
Oh, how's my audio now? Is it okay?
It's okay.
All right. So we're actually on our second version already. So the first one was, just benchmarking with institutions abroad. And even the second one, we continue to, to do benchmarking to revise our IP processes. My predecessor, Dr. Ray Garcia, was instrumental in getting the second revision of our IP policy implemented, and so that was the major round of revision. And as I mentioned in my introduction, we've made several amendments already. In terms of a process, what we've set up, UP is a system of constituent universities. So one of the first things I did was when I took office was to mobilize to form what we call an execom. So these are similar to the network that Attorney Chris mentioned earlier. We established that community of the directors of the different campuses, and then we made it a point to meet regularly. Sometimes as much as once per quarter, so we can try to understand the issues and also figure out how we in the UP system can help in terms of changing kind of support.
All right. So in the case of the UP system, who owns the IP?
Well, we're following the Tech Transfer Act, so it's the university, the RDI in this case. It's
and RDI is
the university in this case, the Research and Development Institution. In this case, it's UP. So that's defined in RA 10055.
Okay. Can you talk to us a little bit about the incentives? In other words, the share, the incentives, the rewards for the inventors in your IP policy?
Right. So we're following the law. There's 40%. If it's government funded, so that's a default. For other situations,
and just to be clear, 40%
of the royalty
ownership
of the royalty.
Of the royalty.
Let's say we have a 100 peso product, and we're able to negotiate a 5% royalty on growth, so that's 5 pesos for every 100. The inventors will get 40% of that, which is 40% of $5, which is $2. So the outside of that, in addition to that, as I mentioned, we've done some tweaks on top of our implementation of the Tech Transfer Act that front loads that benefit to the faculty, so they don't have to wait, to the researchers, so they don't have to wait too long to receive their first royalty or royalty check, so to speak. So so those are the small tweaks that we have been doing in favor of the researchers as well as the CUs.
I know that you mentioned this in your slides, but refresh our memory. So how many patents have you already secured for your portfolio at UP thus far?
Actually, that wasn't in my slide, sorry. I don't have the figure off the top of my head.
Just ballpark.
In terms of, maybe I would prefer to focus on the licensing. So when we did Agambayan 2 years ago, our stats then were about 36 technologies licensed to 66, a total of 66 companies. so that's what we'd really like to focus on. The
Yes.
IP that is, making an economic benefit and not just the IP filings per se. And
Correct.
even as we launched our Invention Disclosure Incentive Award, we've increased our bias towards disclosures for which we have a clearer path to market, and ideally even a lead for an industry partner. So
Right.
that's where we're biased towards, so we can make sure that our IP protection efforts are correspondingly remunerated by licensing and economic impact outcomes.
Correct. Now, I know we're going to talk about the technology transfer later on, but among the licensees that you have so far, are they domestic or are they foreign?
I'm not sure we have a foreign licensee yet. Yeah, it's all as far as I know, it's all domestic licensing.
All right. Thank you so much. Yes. I'd like to turn to you now, Attorney Chris. And basically, I'm going to ask you the same questions. So let's start with your patent portfolio. How many, I think you mentioned this in your slides, but for the benefit of everyone, how many patents do you have so far? And how many have you licensed, if so?
Yeah, we are just starting in the licensing stage, but in the IP protection, I think I mentioned in the slide, we have 26 patent pending patent applications. We have 2 granted patents, and I think more are in the pipeline as we have filed them several years ago already, and several
Right.
UMs. So as for licensing, we have via the tech transfer law, we have one spin out already, which is the catch-all, for traffic management, and we have a term sheet already, and we're finalizing the licensing term. We have one upcoming also spin-off company as one of our faculty. This one regarding drones. So there are 2, and then a third one in the pipeline.
Okay, thank you. What about your IP policy for De La Salle University? How did you go about developing it? And is it a policy that applies to all campuses or just in Manila, or tell us?
Okay, we have a one-page IP policy way back in 2004. When I stepped in as IP director in 2008, we revised it. And what we did was a top-down approach. We drafted the policy and then consulted the stakeholders, faculty, students at that time, and then it was revised several times, very minor revisions. 2009, and then 2011. That's the latest, and then right now we are making an overhaul of the IP policy with the new developments, with the tech transfer law, and with the division now clear to us, between the IP of the De La Salle IP office on one hand and the tech transfer office in another. I'm not sure about other universities how they do it, but for us we have 2 separate offices, for one for IP management and another one for tech transfer. So another feature is we have an IRR, similar to laws that we have. It spells out the details, what to do, who to go to, what office. So the policies are complemented by internal implementing rules, and regulations that would detail the things that the faculty or the student would do if he wants to do IP management and commercialization. And then recently, we just had the first draft of our tech transfer protocol or policy, and it is now up for approval with our approving authority, the presidents, the councils.
Right. So the office that you manage, both for IP management and tech transfer, is that for the entire DLSU system in the Philippines, or
Mhm.
is that just for the Manila campus?
It's only for the Manila and Laguna campus because, as we know, Laguna is now part of the Manila campus. But
Right.
De La Salle Philippines, no, that is the overarching entity that supervises all La Salle schools. By the way, there are 16 La Salle schools in the Philippines. No, uh, they created an IP commission, and I was tapped to be the chair or convener of that IP commission. And right now,
Right.
we have met 3 or 4 times already. We are now drafting our overarching guidelines for IP policies for all the 16 schools. Because I advise them, no, that uh, not to just take the DLSU IP policies, no, hook, line, and sinker, because you have your own experience. So you have to draft it on your own, but we can guide you in the process. So I think that's
So
uh,
the plan then is
yep,
for each.
right.
So is the plan then for each of the 16 schools to have their own IP offices?
Yes, yes, Doc Joel, because each school has its own board of trustees. So they
Okay.
act independently. So each will have its own IP policies.
Yeah. I don't know if you've had a chance to review the IP policy of the University of the Philippines. And if you have, I'd like to ask you, uh, are there significant differences between your policy and theirs? And where do those lie, those differences?
Yeah, when we were drafting our own IP policies way back in 2008, 2009, the IP policies of UP, no, of course, no, is one of our benchmark institutions. We look also at the universities abroad and crafted our own. We have very similar because, of course, in IP policy you have the crucial provisions on IP ownership. No? And so I think this is common to all IP policies. The way it is written probably would be different, but in essence, if you look at the contents, it would be basically the same. It's just that we may have a different sharing. For example, for royalty sharing
Okay.
in the LSU, um, in the end, it would be 54% for the researcher, inventor, and 46% for the LSU. And each will have its own, of the 46%, it would be divided into the college, the unit, no, and the university in general. So um, aside from that, I think we have very similar IP policies.
So that's quite generous. You have about over 50 plus a share of the royalty going to the inventors. I think that's pretty good.
Yeah, I think
um,
yep. The idea there is to attract researchers first,
right.
so that they would be motivated, and later on, if
Yes.
we have the numbers, we can think about it again.
Right, right. So I think it's important to kind of highlight this and underscore this to our colleagues, faculty members, scientists and engineers in the Philippines, because it's a real incentive really for those inventors to patent their inventions and discoveries because there is this financial remuneration corresponding to those inventions as well. I think that's important. Although, of course, that's not the real motive as to why we're encouraging people to innovate. But that's a fair compensation as well. So, in the case of De La Salle University, who exactly is the owner of the IP? Who owns it?
So in our IP policy, by default, it would be the faculty and the student, but it is subject to several exceptions. No, I think there are 7 exceptions to the
Wait, wait.
to the
It's
ownership.
not the. Wait, excuse me, Attorney Cruz.
Yeah.
Are you saying that the owner of the patent is not the De La Salle University Board of Regents?
Unless it is under the tech transfer law, wherein the IP would belong to the university. Outside of that, then for our case, the default is it is owned by the inventor or the author, unless it falls under several exceptions. And the exceptions are quite broad. Like, for example, if the grant was made through the university, so the university would now claim ownership. If there is substantial use of the resources of the university, if it's part of the regular duties. So
right.
If it falls under these exceptions, then it would be university owned.
So typically it would be university owned because that's what happens usually.
Right. Yeah.
Which is normal, by the way. That's the norm.
Yeah. Yes.
That's the norm. All right. Thank you, Attorney Cruz.
Thank you.
I'd like to turn to you now. Thank you. Yeah. I'd like to turn to you now, Dr. Ibanez. Yes. Right. I know that you already enumerated the challenges that you are facing, but I still would like to ask you the question regarding your IP policy. How did you go about crafting your IP policy at Cebu Technological University? Could you please unmute yourself? We cannot hear you.
Sorry. Well, the IP policy has been there for, I think, around 5 years from today. So it's been there. So they have previously crafted it already before me. And they put into there the sharing. But unfortunately, as we said, most of our adapters are mainly from the community. So there's not much into sharing about the even the co-ask questions on how we're going to do the sharing. So while we do have the policies, we are bound by the government rules. We're being questioned also if ever we earn something out of these shares. So we're just parking the policy, and there's much problem in how we deal with our COA also. So it's something that we need to I'm not sure how we're going to resolve that because of these issues on money, and it goes to government funding. Or any money that goes into the coffers of the government would certainly be questioned by COA. That's something we need to resolve as well. It's not just about the sharing that goes with the policy, but also how we deal with the government funds. Thank you.
Right, but Cebu Technological University is a state university. It's a public university. University of the Philippines is the same thing. So perhaps you could learn from UP in terms of what they did to be able to address that issue.
Yes, correct, and that is what we try to do right now. But COA has different interpretations. Different areas have different way of how they deal with funds. So when we try to present, even the people, they say no. The typical example would be the incentives that being given by UP. If we do insist on no, they are UP. It's different from us. So that's a big challenge, and in SUCs, as COA has also different interpretations. So that's a very, very big challenge, I think.
So in your case, with your university being an SUC, who is the owner of the intellectual property?
It's owned by the university, and it gives shares supposedly to those that are who innovated that one.
All right. So can you tell us what's the share that goes to the faculty inventors?
If I'm not mistaken, suppose the 20%, it ranges from 5 to 10, depending on the resources being used. So it depends on if they were using how many percent they used on their time, for example, were they given equivalent workloads or these things? Is it a product of an activity funded by the university? So those things come into play.
Okay. Thank you so very much, Dr. Ibanez. Thank you. Attorney Dicena, I'd like to turn to you.
Yes, Joel, go ahead.
Yes, all right. So thank you so much for enumerating for us the lessons that you've learned, as well as your recommendations. But just to underscore this, what is the top recommendation that you would like to present based on
I
your
think,
experience?
yeah, based on our experience, the very, what we want to be prioritized right now is actually the request for a plantilla position uh, for those who are handling intellectual property rights assistance program, because at the moment we only have 3 permanent staff and the rest are contractual staff. So retention is actually a problem. There is no security of tenure for those contractual staff. In fact, they are fully dependent on the project, which has an end term. So our main problem there is capacitating this staff, and then after they are capacitated, then they go. And so we will again be at the mercy of another project, and then hiring another set of staff to handle the intellectual property assistance program.
Got it. Yes. So DOST has been around now for years in terms of course, providing assistance for inventors, for them to be able to file their disclosures and get patents. And maybe you have actually mentioned this, but it's worth recalling how many patents in terms of the inventors that DOST have helped over the years have been secured, and how many of those have been licensed or commercialized?
Okay, so based on my presentation, I believe starting in 2015 until 2019, we were already able to file. Wait, I'm still looking for it. Around 100 plus patents, 139 patents. And when it comes to commercialization, that is actually something that the institution has still working on monitoring, because not all those who have been filed has been fully commercialized, unfortunately.
Correct. Yeah.
So,
So just to be clear, just to be clear, the number that you cited, is that patent applications, or are those patents that were actually granted?
Oh, applications, just filed patents. At the moment, I don't have the number of how many patents were granted.
Okay.
But for the total filings that we had, only 330 were granted.
Okay.
So that includes utility model, industrial design, trademark.
Okay. Thank you so much. Thank you. DOST certainly is a very important stakeholder and also agency in terms of capacitating, as well as enabling scientists and engineers in the Philippines to protect their intellectual property. So thank you for your service for sure. Attorney Barba, I'd like to turn to you again. Al, don't feel left out. I'll be turning to you too. Attorney Barba, I want to talk now about provisional patents. That is something that we have here in the United States. And again, I'm a faculty at the University of Arizona. And every time that I have a discovery together with my grad students, or engineering design that we would like to secure a patent for, it's very easy because I just contact our patent office, and they can easily file a provisional patent from the US Patent Office in a matter of days, even less than a week for sure. So it's very convenient. And once it is protected, then of course I can publish it in papers, I can give public seminars, and so on and so forth. So do you think there is a need for that in the Philippines? And do you agree that it would be helpful for the Philippines to have such an option to go with the provisional patents?
Well, definitely, it would be a big help for our inventors. That's the main reason why we included that in the proposed amendments to the IP Code of the Philippines. And we seek your support special of PAASE when we file the bill in Congress. And hopefully, the reception will be affirmative in the sense that they will be able to at least understand and recognize the need for such kind of application here in the Philippines. So included also is the parallel filing of UM and patent. That will also
Right.
be a big help for our inventors.
Could you tell us your timeline for the bill or code modification that you have in mind?
Well, right now we're polishing the proposed amendments, and hopefully we'll be able to file it within the next 2 months.
Okay, and how can PAASE exactly help in terms of supporting that move?
Well, part of the processes in Congress is to seek comments from different organizations, different government agencies, and hopefully PAASE will be able to give a push for the bill
Yes.
by sending its position paper.
Yes, both Dr. Sarafika and I can assure you that we're delighted and we're very happy to provide support to you in this regard. So please let us know. We're ready to help. It would be helpful for you to send us some patterns or templates. We would be happy to receive that from you.
We'll be
Thank you so
sending
much.
a copy of the proposed amendments to PAASE once it's finalized.
Okay.
Thank
All
you.
right. Thank you so much. So before we go to our next topic, which is the IP management and technology transfer, Al, I'd like to give you some opportunity. If you could provide some comments or if you have questions pertaining to the scenario in the Philippines in terms of patent applications.
Yes, thank you, Joel. I mean, actually, I did raise my hand considering that I was about to offer to Yusek Roel or now he's ED Roel now, of course, when we met at DTI or Yusek. Yes, definitely the way the provisional helped me actually in the US when I had a small company is that I file a provisional patent where I put in my ideas in the provisional before I meet anyone for potential collaborative research agreement. These are big companies, so I needed to be able to put my ideas on what we own as a company, as a small company at that point prior to the meeting. So to me, that's useful for a lot of scientists who have paper. This actually is a good replacement, if I may say so, towards just going after utility models, because I consider utility models as mainly paper patents. They were not reduced to practice. They were just pigments of the imagination. Sorry, Adrian, I'm using CPU as an example, but a lot of it is really not born out of real years of research, but more of potential ideas that might be worthwhile testing in the lab. And this is where a provisional patent is a similar filing in the US, where you have this idea about what your technology can do. But what it does is after you file the provisional patent, you have a year. If you know how to file it properly, you have a year to generate that data. And you still get, after the end of the year, you decide now, okay, am I the only one practicing in this area? And if not, I will take priority and file a full application based on this provisional. That's what I do. But what it does is that it puts a placeholder of my ideas and potential data that I may generate within a year to be able to protect that technology as I present and talk to potential investors, partners, marketing corp companies. That gives me some sort of a protection already that I know what I own. And from a Philippine perspective, not only it's useful for startups, but we are already discussing that in UP for potential follow-on to the spin-out companies that have now gone out of their shell as professors outside of the UP system to have actual companies that have talked to customers and now need to modify their licensed technology to suit the particular customer. And there's new IP in that one. And I told them, rather than spending too much time filing another full application where you have not even received office action on the first one, I said, maybe we should file, if it's really that valuable, we can file a provisional patent in the US. That way you have a placeholder for the technology. But if that happens here in the Philippines, then we don't have to go to the US and file the provisional there. We can file it here. And then within a year, you can follow it on to become a full application of you've done nothing, you want a you can file that as well. But for me, the ability of having a provisional, actually, I'm drafting a provisional now. I haven't filed it, but I tried to file in the US. I needed assistance from my law firm. I said, okay, drop it for now. But clearly, that's an avenue that is worth exploring. And we at PAASE as well. I mean, I'm glad Joel already volunteered us, but I do feel like we need to support you on that front. So I think that's my take, at least for the provisional patent application. And I think I'll stop there for now. I'll let Joel go back to the technology commercialization because
Thank you for
that's
that,
also
Dr. Al.
you're welcome, Roel. I mean, definitely, we're in this thing together. I know you just sat there for barely 6 months, but definitely there's more work for us to do. We've been
Yeah.
doing synergy and all that stuff with DG Blancaflor and DD Josephine Santiago before, and it doesn't end there. You're my
Yes.
next, you're our next target to
Sure.
help me.
Anytime.
Yeah. So thank you.
Al, thank you so much. Thank you very much. And thank you so much, Director Barba. So now we're going to go into the commercialization aspect. And I just would like to share with you a few slides for our discussion. And of course, I would like for you to react to this. Can you see my screen? Can everybody see my screen?
Yes, we can.
Yes, sir.
All right. So I just would like to share this with you. This is Yisum. It's a company. It's a private company which is acting as the technology transfer arm of Hebrew University. So this is the Hebrew University of Jerusalem, which is in Israel, and this is their website. So Yisum is the technology transfer company of the Hebrew University of Jerusalem. It has over 9,300 patents and 110 spin-offs to its name. It's a 52-year-old company, the third oldest in the world of its kind, works closely with researchers at the university and connects them to commercial partners. That's their main role. Creates an average of 10 new companies annually, with some like Mobileye, valued at over $9 billion today. It has $2 billion in annual sale. Yisum earns 3 to 5% in royalties. 60% of companies' income goes towards researchers and their laboratories. So in other words, it's recycled back to the university researchers, creating 300 new positions each year, with the rest recycled back into the company and the university. Tel Aviv University, the Weizmann Institute, and the Technion are among the top 10 patent applicants in the United States. So this is part of their website of Yisum. And so if you want to search for their various intellectual properties, you can do so under various categories like agriculture, chemistry and materials, nanotechnology, life science and biotechnology, and so on and so forth. So that's one existing model. The other one is this, which is ITRI, which is Industrial Technology Research Institute, and this is for Taiwan. So ITRI is a nonprofit R&D organization engaging in applied research and technological or technical services, founded in 1973. So I got to meet one of their officials actually, because he came to visit me here at the university. So he explained to me that this is, again, nonprofit. They're doing research, and their main goal for doing the research is to produce intellectual properties. And those IP then are then essentially promoted worldwide and licensed worldwide. That is the reason for the existence of ITRI. And so they go to these trade shows all over the world, including in the United States, of course. This picture here was taken in Las Vegas. So essentially, that's what they do. So anyway, I'm presenting this, and I'm probably most of you are familiar with this, at least with IPOPHL. But I thought that this is very informative and quite useful as models for technology transfer. And particularly because in the Philippines, of course, resources are very limited. I mean, good for UP, it's the national university of the country. Good for DLSU, it's a private company with substantial resources at its disposal. But there are many state universities and colleges in the Philippines without much resources, as well as capacity and know-how to be able to handle these matters. So what I would like to present to you, and I'd like to get your reactions for, is what if the Philippines then establishes such an entity that is meant to manage all of the IPs generated by universities and colleges and research centers in the Philippines. In other words, they'll take care of the IP protection process. They will handle the payment so that, again, SUCs don't have to worry about the financial requirements of this process. The government can invest in it. And then that entity will also be responsible for promoting these IPs all over the world and responsible for licensing them. So what I see, for instance, with DLSU, which has substantial resources relatively, is that Attorney Cruz just told us that the campus in Manila and Laguna together, they have their own IP offices and technology transfer offices, but the other campuses of DLSU across the country, are responsible for having their own IP and tech transfer offices as well. So there's a lot of duplication taking place in here, which is, introduces a lot of inefficiency in terms of personnel and use of resources. The same thing with the SUCs. Cebu Technological University, I would imagine, is relatively advanced compared with the other SUCs in the Philippines. And they're very open and candid about the struggles and challenges that they're facing. And we expect the same thing to happen and be duplicated in all the other SUCs in the Philippines. So that's a very tall order, really, to fulfill. The same thing with UP, but good for UP because it has a centralized office that could take care of all of the UP campuses. So anyway, that's an alternative vision here, is to have this national entity, and it could be not for profit, for profit. I guess that's up for argument, discussion. But the government can invest in it. But ultimately, I'm sure there's a way for the government to eventually recoup its investment because it will be foreseen that a lot of these IPs will generate substantial revenues going forward. So anyway, I thought I would present this alternative vision to you, and now I would like to turn to you and get your reaction about this. So let's start with you, Director Barba, if you will.
Yes, I would just like to ask if the Taiwan Institute is owned by the government. Is it government owned or privately owned?
It is government owned, and it is not for profit. So in other words, the government is investing in it. Now, don't ask me about the distribution of the revenues.
Well,
I don't know.
I think it's good to have one here in the Philippines. I'm just not sure which government agencies should lead it because IPOPHL is not mandated to invest in such such companies or entities. Maybe LaSalle can spearhead it, and in a way they're
Or
advanced.
Director Barba, so whatever that entity is, of course, it will be in close partnership with IPOPHL because IPOPHL is the one that will be prosecuting the patents. And then perhaps that entity should not be with a specific university or SUC so that, it remains impartial. So it could be a new entity. And perhaps it's better that it's not a government agency. Perhaps it's better that it really is a company. Whether it's for profit or not for profit is up for debate, but I think it's better for it to be an independent entity. What do you think?
This is the first time I heard of it, but I think it's a good idea to have one in the Philippines. And maybe we can take the lead from Taiwan and Israel also. Our commercial attaches are already on the ground in Taiwan and Israel. And hopefully we'll be able to get more information on how we can set up one here in the Philippines. And maybe you can be one of the pioneer incorporators of that company.
Oh, my role here is with PAASE, the same thing with Dr. Serafika here. So we're here as a facilitator. So we certainly would be very interested in being involved in conceptualizing and formulating this. So we'll be happy to assist in this. I know you're with IPOPHL, so I don't know if this one is taken seriously, who should take the lead in terms of formulating it. But regardless of who that person might be or that party might be, I'm sorry, Al, I'm speaking for you, but I'll give you a chance to react in a little bit. But I'm sure that both of us, with PAASE as well as other PAASE members, would be delighted to provide help in this. So, but thank you, Director Barba, in terms of what you expressed in your interest in considering such an alternative path. I'd like to turn now to Dr. Sisan. Dr. Sisan, I'd like to get your reaction on this, please.
Hi, good morning again. Yeah, I gave a quick overview of our initial efforts in that regard, and we are certainly interested. And so we started doing this work in 2016 with the Glenn Baticados of UP Los Baños. And as part, we did the homework and we endorsed that proposal to DOST. Unfortunately, at that time, DOST declined to fund it. So we haven't pushed it again, and maybe this might be a good time to do so with PAASE support. In terms of other like spin-off entities, in Diliman we also have the Upscale Innovation Hub, and we just got the go-ahead from our steering committee to start exploring the spin-off process, and we're also looking at what Chris presented in terms of the structure of Animal Labs. Those are certainly models that we are looking at. In terms of, so as I said earlier, the biggest challenge is how to get it funded. And it would certainly be easiest to start it with campuses or institutions that would have already the best traction in terms of licensing revenue. So I think my counterpart in UP Manila is here, Ludi Tejero. So and certainly along with the Los Baños, they would be in a good position to explore this because they have some good traction in terms of licensing revenues as well. So those are the general considerations that certainly it is possible. I think we have explored both the legality of it. So I think it's at the end of the day, it's who's going to make the initial investment to move it forward.
But specifically, Dr. Sisan, what I'd like to for you to react is on this idea of having an entity that would take care of the IP management and commercialization for everyone in the Philippines.
We're certainly in agreement of that, and we see the advantages of doing that. Like I said, we did the homework on this already. And you mentioned ITRI, so I think Chris and I were there. They were one of the major institutions to benchmark with over a decade ago.
Wonderful.
I hope still remembers our trip, and that practically got our whole IP ecosystem in the universities, that was with ERDT, mobilized. So we are really grateful to ITRI for getting us started. We spent almost 2 weeks there. Almost a dozen different institutions in ERDT and DOST.
Okay.
So yes,
Thank you so much, Doc.
we're all for it actually.
Okay.
It's more like I said, the devil is in the details and the mechanics.
Correct. Thank you, Dr. Cesar. I'd like to turn to you now, Attorney Cruz. What about from your point of view? What do you think?
As what Doc Louis was saying, no, we had the opportunity to go to ITRI way back in 2009. So we had a training, IP training there. And one of the questions I asked when we were there, how can this entity, government entity, collect or marshal all of the resources for IP and doing it under one organization? And then I asked myself, would this be possible in the Philippines? So, of course, this is open. No, I mean, personally, I am open to the idea, but I also see some complexities in it. No, like for example, when you do this, what form of organization would that be? Would that be government owned? Would that be a GOCC? Would that be a NGO? How do we manage possible conflicts of interest? No, because if it's government and then you apply with IPOPHL, another government entity, although there is always arm's length there might be some concern. No, and likewise, I think that if you create this organization, IP management is just part of it. No, meaning it has to consider everything, no, from human resources to market access to public-private investment to financial incentive. What I'm saying is that probably it worked well with Taiwan because of their semiconductor history. No, they are very good at that, and so there has to be a channel or vehicle that would protect IP and commercialize it, no, through the ITRI. Now, would that be the same in the Philippines? So what I'm saying is, yes, this is possible. We can explore this, but we just have to be mindful of the other things, no, like legal requirements or even ethical issues that might come out.
Right. Points well taken. Thank you, Attorney Cruz. What about Dr. Ibanez? Could you react to this?
Well, personally, it makes the life of researchers easier. In this case, well, we do appreciate the initiatives from IPOPHL. Very helpful, sir. Dr. Barba, very helpful po yung binibigay po sa CPU. And that from the DOST as well, and many others who are trying to help. But somehow, we see some form of disconnect because each of them are behaving separately. We can't even talk to KUA. These are problems which somehow IPOPHL might be unaware of. The DBM has their own regulations also on the funds. So it's really a complex issue that can't be solved by a single agency that we see in here. So if there's a way for us to have that platform that will be able to look into DOST, IPOPHL, and all of these concerns, even the industry linking it to us, because frankly saying, like CTU or any other SUCs are left to scavenge on industries to find among ourselves which one would really fit. So sometimes we cannot, the reach is a bit limited, the connections are a bit limited. So having a certain platform that probably could, in that initiative could help us to somehow harmonize all of these concerns being raised, because not just really one agency could address this one. So we see this limitation, and it's really a challenge for researchers. CHED is even involved because the incentives or the recognitions or even a ranking scheme is somehow not aligned. And I know IPOPHL is trying to propose something also in terms of that. So it's not only one agency that's going to be involved if we're going to deal with this one. So I do agree. I do support if it makes the life of the researchers easier. then I would go for it. I would really support that idea. Thank you.
Okay. Thank you, Dr. Ibanez. I'd like to turn to you, Attorney DeSena. How would you react to this as, being with DOST?
Yes. Actually, the setup in the DOST is somewhat similar now already with that of the E3 and the one that you have made mention, because the Technology Application Promotion Institute is actually acting as the centralized technology transfer office of the entire DOST system. We have 7 RDIs, Research Development Institutes, and we are actually assisting our RDIs in terms of IP management and commercialization. So we are in charge already of protecting their intellectual properties. We are in charge of looking or matching them with potential investors, and also monitoring their commercialization efforts. The only thing is that TAPI, the structure of TAPI is a national government agency, and that all our funds goes back to the treasury at the end of the year. So while the Technology Transfer Acts give us the chance to set up a revolving fund, this is something that is still on the works with our Department of Budget and Management. It's not been approved yet. So in the meantime, the DOST gets to set up this revolving fund, but not the RDIs or neither TAPI. So we're actually thinking of our director has already made some announcements before or earlier to having our institution be converted into a government-owned and controlled corporations in the future, so that we can fully manage really our commercialization efforts. Our mandate also includes providing grants and or venture financing. However, we cannot maximize fully our mandate to venture finance because of the fact that we are not we are not a GOCC. So all funds has to go back to the treasury at the end of the year. But I don't see. I fully agree that this particular system can work. But when it comes to other entities such as state universities and colleges, I think it will be very complex, given that these universities also gets funding from other departments, not only from their own funds. So the other departments of government also has some say on the matter. So I don't know. I don't know how it will work with other entities.
Right, but I suppose that's a matter of resolving the ownership or ownership shares of all of these various sponsors, and of course that will have to be resolved by the particular SUCs or universities, and so that will have to be resolved before they communicate or they work together with this particular entity. So you're saying that there is this idea within the OST that perhaps your unit could be spun off, and is that the thinking for it to be separate from the OST or still part of the OST?
Still attached to the DOST, but the structure would be a government-owned and controlled corporation, so that we will have some fiscal autonomy or flexibility.
Yeah, so this is very informative to me. But currently, in terms of your promotion of this intellectual properties, are you able to do that currently both locally and globally?
Yes, actually, one of our functions is to promote the technologies that is generated by the department. So we also assist our technology generators or owner in promoting their products locally and abroad.
Okay, tell us a little bit in terms of how you're promoting it abroad.
Actually, we participate in exhibits, international exhibits, where the technologies generated by the department is being showcased. So that is actually a one platform in promoting our technologies here. We also join contests that is sponsored by WIPO or Geneva, at Geneva, and some sort of like that, and also with our industry networks and linkages. So that is how we actually promote the technologies of the department.
Okay. Thank you so much. This is extremely informative, and of course, we're going to continue this conversation. Dr. Serafika, I'd like to give you some opportunity to react.
Yes, clearly, I mean, first of all, I have to commend the group of Attorney Ivy, indeed, and Egay Garcia, who's the director of TOPP. They have done a very tremendous job. It's out of their comfort zones for a couple of years now in terms of what they're being asked by you, Sec Kevin, Sec Boy, to do for technology promotion, licensing, and they've tried tremendously to seek our help as well from my Balik scientists as well as our visiting experts with Larry Ilag. We're helping them on RDI technology commercialization in earnest. But going back to your two presentations, I'm familiar with USUM. I visited actually Israel in 2018 and was in Technion, and I saw the revenue and their technology commercialization aspect out there and the companies that they brag about being up there in Technion, looking at all their startups, their Silicon Alley, or I forgot, Silicon Valley. It's a valley also where the companies were. And to me, I think when UP explored that idea, I remember Glenn talking about Cambridge One also, which is the Cambridge model for marketing their IP, which is a single entity where they spun out all their technology. It was too early for its time. At that point in time, I think in the Philippines and our growth, we were still just perfecting our IP filings and our spin-off capability, and revenues were not yet coming in. But there was a model in one of the IPOPHL USAID Stride event in 2018 called Synergy in Manila Hotel, where there was actually a French model, which I liked, which I told Attorney Chris at that time. I don't know if Chris remembers it, that I said that's what I want to be in our animal labs and Depo Dito as when we grow up, because it was a private public partnership. Basically, they have a board composed of banks and industry people. They have actual business people and venture capital arm marketing groups. Then they have representatives from the CERN, their national labs, that brings in all the IP to this venture, and then but it's managed by as a private entity and promotes it and shares the equity to the inventors and to the national research group. So to me, it was an ideal looking at it as a DOST UP. Right now, it has started actually with DOST because DOST is the main funding arm. They have grants all over the universities. So they can do this on their own technically, but because of lack of personnel and inflexibility of the outfit, indeed, I agree with Attorney Ivy, it needs to be spun out. And it needs to bring in private capital. Because right now, private venture capital is non-existent in the Philippines. But if you can demonstrate value in the IP, matching funds from government, private institutions will bite. And if you have the universities to support it and the facilities in these universities to be able to continue the work, this is the incubator, these are the spin-off companies, all together can be become a sustainable, profitable venture that I think it can be a non-profit, but I'm an entrepreneur as well. I'm a technopreneur as before, so I do look at the profitability, and again, there's a certain level of profitability that you need to be able to pitch to private individuals so that they'll open up their wallets. And I think that's where the challenge is. If it's a nonprofit, then you're just purely appealing towards the national building and development aspect to it. But I think the center itself, I did propose in NAST during our meeting with capacity building about the description of a national R&D commercialization and technopreneurship center. It can be a virtual center where all the collective knowledge of UP, LaSalle, and everybody else can go to, put it there, And Stride can probably, hopefully, support that. We do have the center envisioned like that already for grant writing already. So what more to extend that to technology commercialization and technopreneurship. So Stride can probably initially, hopefully, if I pitch them correctly, can look at that as an extension of the other activities that they've been promoting in the last 7 years. But at the same time, during the last stage of that, when you bring in private capital, that's probably the key. Because to me, in again, nothing against the Jews in Israel, they always are very frank about it. That they said, if you don't bring your own money, they can't do anything for you. You have to bring. They're very astute businessmen as well, even in research. And they said, we'll collaborate, but you have to bring in your fund. And if the farmer takes on the project, it has to be profitable. It has to have a rate of return on the investment. So we have to think in that regards. And right now, being in UP and in the academic institution and in government, where whatever effort that you do returns to the treasury anyway. So what's the incentive? So that's what Attorney Ivy is talking about. We had this meeting with PNRI. We were trying to scale up their gamma sterilization facility, so we'll have a medical device industry. And then they said, Al, if we do that, anyway, any extra amount that we earn from gamma sterilizing medical devices will just go back to the treasury again. So there's no incentive for us. Why don't you spun it out as a either a public partnership in order to retain the earnings even for all the efforts that you've done? So clearly, as Chris mentioned it, there's a structural difficulty of dealing with the existing laws if you put it in government. And Attorney Ivy is in agreement with that. So it has to be outside at the minimum non-profit. But again, I'm open to doing a for-profit institution where you do an arm's length negotiation to transfer all the IPs from the different institutions, consolidated in one. Not much difference from the IP ventures of Mirvold about the patent trolls, but this time for nation building. So that clearly is a strategy that's worthwhile exploring, but with a more of a nation building, national capability kind of point of view. Thank you.
So thank you, Al, for that very insightful comments that you made. This is a form of national entrepreneurship. We're talking about entrepreneurship, but even the nation itself has to be engaged in entrepreneurship. And these IPs that are generated within the country, they have they have real value. And so the nation can capitalize on them and promote them aggressively globally so that value could be created and revenues could be created for the country as well. So this is a topic that certainly we should pursue, and we need to have a serious discussion on offline. And so Al, please help facilitate. I think this is a great steering committee here in terms of what we have here within the panel, representing the various sectors of the universities and research institutions in the country, as well as with IPOPHL. Our time is up, but I'd like to give the last remarks to Attorney Barba, Director Barba, if you could give us some parting words pertaining to this.
Yes, first, I would like to address the concerns of Dr. Adrian, and I think I see some of this in the comments of the delayed receipt of action papers from or documents from the IPOPHL. Maybe they were also affected by COVID, unfortunately, especially the services of our field post. So I suggest that I apologize for that, but I suggest that they utilize our eDoc and eCore, our online services. So there will be no more delays in the receipt of action papers. So, and I would like also to take this opportunity to thank UP, LaSalle, and Cebu Tech for their active participation in promoting innovation in the Philippines. I hope that they'll be more active in our ITSO network, and hope to work with you more in the coming months. And right now, I think this is the most opportune time that DOST, DTI, and IPOPHL are collaborating together And hopefully we'll be able to do some more projects, especially in our regions, promoting the regional inclusive innovation centers. So hopefully we'll be able to start that in the soonest possible time, together with our ITSO network and some universities and even businesses, no? As stated by Dr. Adrian, they're having a hard time connecting with the industry, with the DTI on board, since they're in charge of industry promotions. So there'll be more linkage, no, between industry, academe, and the government this time, because it's now the time to have demand-driven research. So there'll be more at least chances of commercializing. And right now, I think DTI also working on the promotions of our startups and innovation. I think they're now also talking with Plug and Play, and hopefully we'll be able to do some projects with them as soon as possible time. And we thank Stride, especially Dr. Richard Dabendan, who made it possible for us to be in the US, I think 2 or 3 years ago, to check on the Triangle, Silicon Valley. And I think that was the time when the National Innovation Act was forged between DTI, the OST, and the other government agencies. So hope to work with you in the next months. Thank you.
Okay, and Attorney Barba, we're going to continue this conversation here. And can we count on you to participate in this discussion?
Sure.
Okay,
yes,
all right.
anytime.
Thank you. Yes, yes. So I would like to thank our distinguished panelists, Attorney Barba, Dr. Cisan, Attorney Cruz, Attorney DeSena, Dr. Ibanez, and of course, Dr. Serafica, for this highly productive discussion that we've had today. And for the audience, I hope that you learned quite a bit from this highly informative and also quite a probing and exploratory discussion that we just had toward really strengthening the IP protection and also promoting commercialization of these intellectual properties, both in the Philippines as well as globally. So we thank you very much indeed. And again, the Philippine American Academy of Science and Engineering greets all of you, and thank you for joining us for the 40th anniversary panel discussion. Thank you so much.
Joel,
thank you very
people
much.
are asking for a group picture.
Thank you, everyone. Thank you, Attorney.
Oh, wait.
Group picture.
We need there's a group picture requirement here. So, Mon, are you the one taking care of this?
Yes, sir. May we request everyone to please turn on their webcams. Thank you.
All right.
Please bear with us. We are 50 strong, so this will take a while.
So everyone, please turn on your camera.
Please turn on your camera and your virtual background if you're not so comfortable with your background. All right. Okay. Right. Okay. Okay. I'll be starting in 5 seconds. So if everyone's yes, Ma'am Anna, please smile with us. Okay. If everyone's ready, please flash your best smile. 1, 2, 3. All right. That's for the first screen. I have multiple screens. Please wait. Okay. For the second screen, I hope everyone's ready. 1, 2, 3. Please flash your best smile. Thank you. That's all. Salamat po.
Thank you,
Again,
everyone.
thank you all very much. Good morning in the Philippines. Good night in North America. Thank you.
Good night, Joel.
Thank you, Joel.
Bye.
Doc
Thank
Al.
you.
Thank you.
Bye-bye. Thank you.
Thank you.
Bye.
Thank you, everyone.